Does that answer your question?
I hope so. All right. Well, again, so here we are. The spouse isn't doing what she's supposed to do. Are the children entitled to an accounting? With, what can the children do?
The usual rule, well, sometimes the trust says whether somebody's entitled to an accounting.
Mm-hmm.
In the absence of a specific provision in the trust, the general rule is that the person that's entitled to the income is entitled to an accounting. Well,
Okay.
during the surviving spouse's lifetime, that's the surviving spouse.
Okay.
However, there are statutes that say that even a remainder beneficiary is entitled to what's loosely called a report.
Mm-hmm.
And he's entitled to it over at a reasonable period of time, not every month, not every week,
Mm-hmm.
not necessarily even every year.
Mm-hmm.
But periodically he's entitled to a report of what's there, what's left, is the principal still intact,
Mm-hmm.
how much of the principal has been spent. Now, more and more of that information eventually becomes an accounting.
Mm-hmm.
And the courts have not said that the children are entitled to an accounting, but they often get a report that supplies a lot of the information that's in the accounting. And frankly, you can understand why the surviving spouse thinks that that's putting their nose in her business. But that's the law, and the children can find out what's going on with the money.
Yeah. Are children from the first marriage usually a good choice for a successor trustee?
Worst choice in the world. Absolutely the worst. I mean, you have to understand that often children develop not all of the positive traits of their parents. They will develop the negative traits. You might have a son whose father was, how do they put it, tight as a tick when it came to money.
Mm-hmm.
So he decides that he's going to follow in his father's footsteps and tell his mother that from now on she has to shop at the Goodwill store,
Mm-hmm.
or she can't buy anything that's more expensive than Target brand.
Mm-hmm.
That's the worst possible decision, and I strongly recommend against ever making a son or a daughter the person in charge of the mother.
Okay.
You might have the son or the daughter who, if they're very close, the stepson or the stepdaughter help with the medical decisions because there may not be anybody close by.
Mm-hmm.
But money is different than medication.
Mm-hmm.
And frankly, I would never put the children in as the trustee for the surviving spouse.
Okay. So what about health care directives and durable powers of attorney for health care? And I guess we're saying in the second marriage situation and you're making plans, and so you're still married, your spouse is still, your second spouse now is still living. Should they be the person that should have these powers, do you think?
Usually, yeah. Pretty much every spouse makes the other spouse be the person that's going to make the medical decision on pulling the plug, as they say, with withholding nutrition and hydration, pain medication, for example. And usually they'll pick a second and third choice. Some people often will size up their children and they'll want one of the children who is probably better able at making that decision. But another big factor is how close they live to the family. I mean, if you've got a son who's very mature and very capable of making those hard decisions, but he's working in India, doesn't do you a whole lot of good if you're sick here in San Jose.
Right.
Because the doctor wants to see and talk to somebody who's got that particular power. But I very seldom see anybody putting the child in charge of that medical decision before the surviving spouse. Now, even in an intact family, if the husband becomes deathly ill, the wife will often consult with the children. But the purpose for having this uniform health care directive or advanced health care directive or power of attorney is so that the surviving spouse or the designated agent can make the decision without getting the consensus of anybody else.
Okay. What special considerations apply to retirement accounts that were earned before a marriage?
Well, that's pretty much his separate property, but there's something called qualified federal benefits, in which case the surviving spouse has to be the beneficiary of those benefits. In the absence of a document signed by both the deceased spouse, obviously before they die, and their surviving spouse, that it can go some other way. So in other words, there you got a little bit the federal law coming in for qualified federal plans. But in other situations, the money can be directed to be distributed by the deceased spouse any way that they want, just like any other property they have. If they have $100,000 or $200,000 in an IRA, and they want to leave it to, well, I could say their child, they can do that. Now, if part of that money was earned after the date of their marriage, well, then part of it's community property and part of it's separate property. And even if the deceased spouse had designated a child, the surviving spouse would have her own community property claim to half of the money that was community property. And that's often where you will wind up getting involved with forensic accountants like yourself to help decide, to help break down what part of this is community property, what part of this is separate property.
But this sounds like something maybe they should be talking about before they get married. It's a little bit like, you know, property agreements in general or whatever.
For whatever reason, spouses are often reluctant to talk about what belongs to you and what belongs to me. Mm-hmm. It can often lead to a fight. What do you mean that belongs to you? We've been married for 20 years. We've been using that cabin up at Lake Tahoe for 20 years, and I've been up there cooking and cleaning and helping repair it and doing all this maintenance work, and now you tell me I don't own an interest in that cabin at Lake Tahoe? So sometimes they will not make a clear distinction or a clear itemization as to what's yours, what's ours, what's mine. For just that reason, they don't want to get into a fight. But then after one of them dies, the other one is often shocked to find out that she does not own any interest in it. And lo and behold, he left that cabin to his kids.
All right. Do you think it's a good idea to tell children in advance about what the estate plan is?
No, certainly not. Some parents have an overwhelming guilt urge to tell their children that we're going to be taking care of you. And it bemuses me, if it wasn't so sad, to see how tied up parents get about how much money they leave to the children and how they leave it impeccably fairly. The bottom line is that how much money your children inherit will have very little impact on their future happiness. It's true for a short period of time. They may be secure, but if they didn't learn how to make money and save money themselves, it'll be dissipated soon. The most important things to your child's happiness is his marriage, his children, his health, obviously, and his job. After that, how much money they inherit really isn't that significant to them. And yet I will see spouses just agonizing as to how to divide up the money among the children. Now, most people divide it up equally. But even that kind of confuses me because while you're raising your children, you never treat them equally. Some have more needs than others. Some have more abilities than others.
You're supposed to.
Well, I don't think so. I'm not so sure you do. I mean, every parent, if they thought back about it, thinks, well, Johnny needed special attention for a variety of reasons. And Mikey was just always a go-getter, and we could always rely on Mikey, and we didn't have to direct that much attention to him. Does that mean that Mikey should get less than Johnny or vice versa after you die? I'm not so sure. I don't think people should agonize that much about it.
Okay. Okay, you're a litigation attorney. Aren't estate fights expensive?
Extremely expensive. In fact, unfortunately today, with there being so many lawyers and so few new opportunities for making money, very few deals going on, very few things to deal with environmental problems, except litigation that the big firms are handling, all of a sudden the lawyers are trying to find areas where there's a lot of money for a simple reason that money can pay their attorney's fees.
Yes.
And they see a $20 million trust. Well, that's $20 million worth of legal problems that one has, even though it might not be that difficult to reconcile the issues. But the more money that they see, the more the lawyers will attach themselves to that, and the more they'll find legal issues that nobody ever thought about. So unfortunately, the bigger the estate is, the more likely it is that there's going to be litigation, just because, I hate to say this, my fellow counsel will find that a lucrative way to make a living.
Oh dear. Okay, well, we just have a couple minutes left. Maybe I'd let you just offer some words of wisdom for people who are in a second marriage situation and an experienced person in this department. What are some thoughts that you have to offer to try to make life a little easier, and especially for your family once you're gone?
There are many good lawyers. Now, whether they call themselves estate planners or will drafters doesn't make any difference. By word of mouth, you can find out who they are, and you can go on their websites and you can find out about them. It is foolish if you've got a multi-million-dollar estate to go to somebody that's giving you a special newspaper advertisement for $299 trust if you come in before Christmas. You're going to spend $3,000, $4,000, $5,000, $6,000 on any estate plan. And you know, the problem is all you're going to get is something that you don't know how well it's going to work until you're dead, and then you're not going to know it all. So you go to a decent estate planning attorney, and the one rule of thumb is this: if he starts talking to you about concepts that he can't make you understand, then run. Because if he can't break them down so that you understand them, it's probably a good sign that he doesn't understand them. But then, even after one of you passes away, I know the theory is that you never have to go to a lawyer again. You do. Now, the living trust will help save probate fees. It will help expedite probate, but you should talk to the lawyer. And sometimes it'll be necessary to talk to him maybe as much as once a year, just to keep things on the straight and narrow.
Okay, Mike.
If you're talking to for short periods of time, it shouldn't cost that much.
Okay. Thank you very much. It's been a pleasure having you as a guest. We're all out of time. Folks, see you next time on Financial Insider Weekly.
Can I say hi to my wife?